what is very common with Canadian and US investors because of the appreciation in property prices is a home equity line of credit or cash out refinance. And here I'd like to focus in more on Canada and US to say that when you're drawing funds out of a home equity line of credit, the government needs to understand that the down payment was made from legal sources. Definitely the most common sources, ordinary income, which is your salary that we touched upon previously. W-2 or T4s in Canada exclusively are not enough, right? Visibility into your bank statement is extremely important because the government's looking for accumulation of wealth. We are outside document limits, retention period in Canada, hence we're not able to provide bank statements, but we attest that this money was legally earned and these legal funds were now invested for the purchase of this asset that now I have received as inheritance, and now I passed on that inheritance to my child who's liquidating it for EB-5. So we need to be very careful and go back to the inception of the source at all times, no matter how old the source. The final point is with gifts and inheritances is gift tax. For example, Canada does not levy a gift tax. We don't need to worry about that. However, we do need to educate USCIS on that matter. So I'm just going back to gifts and inheritance. F-bar comes up quite frequently. If the gifts are being given for an account and the aggregate value of those is over $10,000, in the past we've been asked for F-bar filings because the law is that if you have foreign accounts with aggregate value of over $10,000, you're required to disclose it to FinCEN and F-bar, and those filings need to happen. The country being current is a question for India, China, Vietnam. It is not so much of a question for Canadian clients. The major benefit that my H-1B clients or my Canadian clients that are here on E2 or TN or F1 have gotten from adjustment of status is it stops the clock. What do I mean by that? Once you file your adjustment of status application along with your EB-5 application, you are no longer beholden to your H-1B visa, your TN visa, your F1 visa, your E2 visa. It is amazing what the transformation to the EB-5 visa has done for all these H-1B clients, F1 clients, students that are living here, and Canadians that are here on a business visa. And there are one of two options when it comes to immigrating from Canada. Option one is you go through consular processing, which is where you're applying from Canada. Say you've invested in Twin Lakes, you get an approval in 9 to 12 months because there's no backlog. You are then approved, USCIS approves your 526E application, forwards it to a contractor that's called the National Visa Center. That process of transferring takes about 4 to 6 months. Once it's transferred, the National Visa Center issues what's called a fee bill. That fee bill is a $345 bill per person on that application. So if it's you, your spouse, and 2 kids, you'll have to pay $345 times 4 as a fee. You pay that fee, you finish your immigration forms, you provide birth certificate, you provide your marriage certificate, you provide a police clearance from the province you're living in. Once all of that is submitted, the NVC packages that as one document, sends it to Toronto Embassy, which then conducts the interview for the EB-5 visa holder. The interview is usually 5 to 10 minutes. All the embassy wants to know is, what projects did you invest in? Where did you get the money from? And what do you understand about the terms and conditions of the project? It is more of a formality than anything else. That is the consular processing step, which does tend to take 18 months to 2 years for the entire step, the finish from start to finish. The second option that Canadians have is if they're in the US or if they have the ability to come to the US, and we can talk about what options are available, they can come to the US on what's called non-immigrant intent visas. This could be your TN visa. This could be your E2 visa. This could be an F1 student visa. And again, with the caveat that Canadians don't need a student visa, they need an I-20, right? So it is an F1, it is a student visa, but it's basically adjudicated at the border. We can go through those in details. But once you enter the US on any of these 3 visas, you then have to wait 90 days. You wait 90 days because you do not want to contradict what you've said to CBP. Customs and Border Protection at the border saying, yes, I'm coming for school. Yes, I'm coming for work. Yes, I'm coming for E2, and it is temporary. I don't plan on staying back. So within those 90 days, we recommend our clients don't take any action, whether it's liquidating funds. You can certainly start due diligence on projects. You can talk to the attorney, but we do not recommend signing any document that would have any indication that this process started within those 90 days. After the 90th day mark, these visa categories now have the ability to file their EB-5 along with the adjustment of status application, which would be the 485 application for a green card, 131 application for travel permit, 765 application for work permit. This is really great. The one thing I will say that I get asked by a lot of Canadians is, if I do file this adjustment of status application, now can I leave the country before getting the travel permit? And the answer is no. And here's why the answer is no. All these visas are non-immigrant intent visas. Once you file adjustment of status and you leave the country before getting a travel permit, you have abandoned your 485. You try and then re-enter. CBP sometimes has the ability to see what immigrant visa you filed, or if they ask you a question, if you have any petitions pending, you will have to lie. Once you lie, you have committed perjury. So in any of these visas, you have to assume that you're going to come in, wait 90 days, and wait an additional 4 months. If you do not have the ability to stay here, you need to go, you have a business in Canada, do not file for adjustment of status. You can file the EB-5, you can go back and forth between both countries. There are no restrictions after filing EB-5. You just cannot adjust status. But if you are going to file for adjustment of status, you need to wait within the US until you get that travel authorization to be able to cross the border.
So to summarize, for Canadian clients, they have the ability to enter the US with a visa waiver. They can stay 6 months, but a lot of times, you know, you want to retire, kids need to go to school more than 6 months. So 6 months isn't enough. They want to be here 350 days a year. And so to do that, they're going to have to get on one of these 3 visa categories first to be able to do the adjustment of status, so that they can come in and then get the work and travel permit.
Yeah.
If they're not in a huge rush and they're willing to wait, you know, year and a half for their I-526C to be approved, then no problem. They can just stay in Canada, apply from Canada, and then once they get the temporary green card in their hand, then they can move to the US and then never have to return to Canada.
So I think F1 rules for Canada are the most lenient rules across the world. If you're Canadian though, you are issued an I-20 by your school. What's an I-20? An I-20 is a document, which is an affidavit of support that is issued by the college, and it's registered with the Department of Homeland Security. You basically take that document that's issued by the college after you get admission, of course. You take that, and it has to be a full-time program. You're not qualified to do part-time programs. You take that to the border. They'll ask you questions about what program you're going to study, why, what are your plans. You answer those questions, and you're generally waived through. You get an I-94, which is basically CBP stating we've granted you legal entry on F1, but you do not have to go through the process of a counselor interview like other countries do. It is a very easy option. 90 days after they enter, if they like it here, you know, they like the test run, they can then do EB-5 90 days after entering. Just again, I think it's very important to keep in mind that at the border, there can be no indication that you want to stay for an EB-5 or that's your future plan. At the border, this is about, we are coming here for school, and once school is done, we will be leaving. What I most often tell my clients is, give it a test shot. I don't want you to enter with the intent of doing EB-5. This is more of a test run to see if you can operate in the United States for 90 days. Because again, we do not want to lie at the border. The implications of lying at the border are a lifetime ban from the United States. So again, this is a test run. Come for 12 credits, see how it works, see if your family is able to adjust, see if you're able to, your spouse is able to run the business locally, you know, and if all of that works out, then consider EB-5. The TN visa is only available to nationals of Mexico and Canada. This is basically created under NAFTA, where Canadian clients need to have certain qualifications and need to be on a list of a qualifying job. We've seen, though, Canadian investors don't have a line whether they go rural or they go urban, so they're more open to evaluating both. Meanwhile, clients from Europe, from Canada, people that are born in Australia can afford to go in an urban TA project and benefit from the 5% return, right? They can benefit, they're gonna wait the same amount of time whether they go rural or urban. I think similar thing also applies to Canada, Sam, is Canada has a really high tax rate. And so what ends up happening is most of our Canadian clients tend to take out loans from their corporation, so they're not taxed at this massive tax rate, right? And that's a perfectly okay strategy as long as you can document that the money earned by this corporation is legal, that it's been filed with the CRA, that these documents are available on the CRA website, that the loan is properly accounted for, the loan is payable to the company. If all of that is done properly, there are no issues dealing with USCIS.